Hi, I'm Nancy Cavey, National ERISA and Individual Disability Attorney. Welcome to Winning Isn't Easy. Before we get started, I've got to give you a legal disclaimer. This podcast is not legal advice. The Florida bar tells me that I have to say this, but I will tell you, nothing will ever prevent me from giving you an easy-to-understand overview of the disability insurance world, the games that disability carriers play, and what you need to know to get the disability benefits you deserve. So off we go. Today, I'm going to be talking about nurse-centric short and long-term disability claims. Nurses are the backbone of the medical community, and they've been integral in combating the COVID-19 pandemic. Disability claims are highly scrutinized, and the same goes for disability claims of nurses. So let's take a look. First, I'm going to talk about a registered nurse with Cushing disease who was awarded LINA short-term disability benefits. Next, I'm going to talk about a nurse anesthetist who was self-treating their insomnia and unfortunately passed away. We'll talk about why that claim got denied for accidental death and dismemberment benefits. And lastly, I'm going to talk about how the general workplace standard of occupation and a medical trainer nurse disability policy doomed, ultimately, her disability insurance claim. Now, just because I'm talking about nurses doesn't mean that there isn't anything that you can learn. So listen up. Let's take a break first, though. Welcome back to Winning Isn't Easy. I'm going to talk about a nurse anesthetist who was self-treating their insomnia. Do you know that accidental death and dismemberment policies will often exclude the payment of AD&D benefits for a death caused, resulting from, or contributed to by alcohol, prescription, non-prescription, and illegal drugs, medication, intoxication, and or narcotics? Now, that's a pretty broad exclusion. And the key to the application of the exclusionary clause starts with the policy or the plan language. Unfortunately, there is no uniform policy or plan language, and you've got to get out your particular policy or plan. And when a lawsuit ends up in court, the judge is going to begin their analysis with a policy or plan language. In the case of Baptiste versus Securian Financial Group, Judge Altman of the Southern District applied 11th Circuit case law to this AD&D claim. Now, every federal circuit has its own approach to the analysis of a claims denial, and the 11th Circuit is no exception. In the 11th Circuit, which is in Florida, we happen to use a 5-step sequence in determining whether or not a claim denial is arbitrary and capricious. In the 11th Circuit, a claim administrator's denial of benefits is going to be upheld by the court if the denial is reasonable. Now, what's key is that the administrator's decision is reasonable if it's supported by some reliable evidence in the record, even if the claimant or the policyholder's position is reasonable. Now, in this case, Baptiste, who sued on behalf of his brother's estate, advised in the claim that his brother was a nurse anesthetist and had been self-treating insomnia for years with IV medication. And unfortunately, Baptiste's brother passed away because of an overdose. The amount of benefits was $673,000. And the carrier denied this on the basis that the death wasn't an accident, as defined in the terms of the policy, that the death was excluded under the drug exclusion. And they also invoked the crime and felony exclusions. In my view, this is the trifecta of defense theories that are commonly seen in drug overdose cases. The brother had been found dead in his apartment with an IV inserted in his hand and vials of medication scattered throughout the apartment. The medical examiner concluded that there was no evidence of an injury and that the manner of death was an accident with the drug use as the cause of death. Unfortunately, the toxicology report revealed a number of substances, including ketamine, lidocaine, metoprolol, and fentanyl with a blood alcohol of 0.17, obviously intoxicated. The claim was denied, and ultimately, when a lawsuit was filed, Judge Altman had to decide if the drug exclusion applied. Now, Baptiste argued that the policy was misinterpreted. The Securian had misinterpreted or incorrectly applied the term narcotic and claimed that his brother, who was a nurse anesthetist, could legally self-treat. Funny, it was funny in that there was no pharmacy records of any medication that had been found by a toxicologist. So unfortunately, it appears as if the brother was basically stealing this and probably stealing it from the medical facility that he worked at. So as a result, Securian, the AD&D carrier, also invoked the crime and felony exclusions on the basis that the brother was in the possession of controlled substances and unprescribed medication in violation of the law. Now, so what did the judge do? The judge first started out by finding that the policy required that a bodily injury be evidenced by visible contusion or wound, and that it has to be the sole cause of the death or dismemberment. Unfortunately, there was no such evidence on the body. So the judge found that there was no accident. And the judge then went on to the next question, and that was whether or not this was intentional or whether the brother had subjectively expected that his actions would result in death or serious injury. Now, if the court can't determine the deceased's subjective expectations while using drugs, the court will use an objective analysis and ask whether or not someone with a similar background or experience would have expected an injury or death to result in these circumstances. What the court found was that the deceased brother, the nurse anesthetist, was not legally qualified to prescribe and administer the drugs on which he overdosed. The judge said, look, it's really fair to say that a reasonable person in his shoes, given his extensive training and experience, would have known that injury or death would have resulted from the act of ingesting not only enormous amounts of alcohol, but a cocktail of unprescribed medications. The judge ultimately ruled that the death was not a covered loss. And even though the judge could have stopped the analysis at that point and said, I'm denying the claim, the judge went on and found that the exclusions, the criminal exclusions that had been raised, also applied. And using this trifecta of denials, the reasons for the denial, the 11th Circuit upheld the denial. And now I will tell you the result potentially could have been different in a different circuit with different plan language, but you can see that the plan language and the facts of the case matter in whether or not a case is compensable and whether or not a judge is going to uphold or overturn a claims denial. Got it? Okay, let's take a break.